appeal of the case and others against Recovery Partners GP Ltd and another.
Yes, Mr. Crowe.
I'm grateful. Where we left off yesterday, I had just had a little detour into the significance of the commercial context. And you'll recall that our strategy is to follow the sequence in our written case. So if we could open that at paragraph 10, page 191 in the bundle. And you will, I imagine, have recognised that the approach we have tried to take in order to assist the analysis is first of all to identify what the rule is, secondly to identify its principal basis, thirdly to explore its current scope, and fourthly, in light of that, to examine whether the introduction of a but-for test is consistent with its principled basis, its current scope, and its intended purpose, and thereby to test whether the appellant's arguments justify the introduction of that test. Now, of course, the case law doesn't deal with issues in such a segmented way, so as we go through case law, we'll be touching on different aspects of it, but in order to aid the analysis, we hope it's helpful to take things in that sequence. So in the first section, the introductory section here, we simply seek to identify the rule, which I don't think is really in doubt, which is that a fiduciary must not make an unauthorised profit from their fiduciary position and must account to their principal for all unauthorised profits received. Many people start, and we have started, I think, chronologically with Keach and Sanford. It is more often cited than read. And it is blissfully short, so it doesn't take very long to read. And it would, we suggest, be potentially helpful just to go to it. It's page 1862 in the bundle, because in just literally a few lines it encapsulates quite a few important themes. So page 1862, I don't think I need to summarise the facts. The Lord Chancellor, you'll see at the bottom of the page, says, "I must consider this as a trust for the infant, for I very well see if a trustee, on the refusal to renew, might have a lease for himself, few trust estates would be renewed to seti quae use. Though I do not say there is a fraud in this case, yet he should rather have let it run out than to have had the lease to himself. This may seem hard, that the trustee is the only person of all mankind who might not have the lease, but it is very proper. That rule should be strictly pursued and not in the least relaxed, for it is very obvious what would be the consequence of letting trustees have the lease on refusal to renew to seti quae use." And so, just in those few lines, we suggest there is the underlying principle of not being allowed to take an unauthorised profit, which is, secondly, not based on the need to demonstrate any misconduct by the trustee in the sense of bad faith, undervalue, or anything of the kind. And third point, it is a bright line rule in the interests of ensuring good conduct. And those are the themes that we will see running through all the rest of the case law. So we suggest that the critical points, going back, we can put that away, going back to our case, We suggest at the very outset in para 11 that the critical points are always to keep in mind, I'm stating the obvious, but worth emphasising at the outset, that the remedy we're talking about is a remedy accounting for profits, not compensating for losses caused, and that obviously is a theme that runs from the nature of the rule that we have just identified. And we suggest in paragraph 12 that the reason why the rule is as it is essentially founded on the very nature of fiduciary relationships. And in paragraph 13, we start with that approach as to what is the essence of a fiduciary relationship. And again, we cite unimaginatively, but we hope helpfully, the classic articulation of Lord Justice Millett in Bristol and West and Mothew. Again, often cited, not often read, but again, it has some useful contextual points that have resonance in the later part of the argument. And I was just going to ask to go back to that, not just for the well-known and often quoted short passage, but for some introductory remarks too. So Bristol and West and Mothew is in the bundle at page 1484.
Just before you go there, Mr. Crowe, your statement of the rule at paragraph 10 of your case must not make an unauthorised profit from his or her fiduciary position.
Yeah.
Now, that is that the formulation you are saying is well accepted and well laid down?
Yeah.
I mean, are you able to take us to any case that precisely formulates the rule in that way?
Well, I was going to do that, but that's the word "from" in a sense sort of drifts us into the sufficient connection issue.
Exactly.
So I was going to try and engage it then. If
Thank you very much. Thank you.
But I mean, in Mothew, Lord Justice Millett talks about making a profit out of.
Yes.
So
out of.
I mean, there are various ways of expressing it. But it runs through the case law. The concept is that there must be a connection between between the fiduciary obligation and the profit.
100%, absolutely. So Bristol and West and Mothew. This is a relatively well-known case in which a solicitor was being sued, having acted for both the purchaser and the lenders in relation to property, and you may recall the lender had agreed to extend a loan on condition that the balance of the purchase price was funded without a second loan, and the solicitor negligently fails to tell the lender that the purchaser was in fact borrowing part of the balance. And it was one of those cases where a purchase of land was completed, the borrower defaulted, and the property was sold at a loss. And so the main question in the case was whether the solicitor was liable for the difference between the loan that was advanced by the lender and the ultimate sale price, or whether he was liable only for the loss occasioned by the existence of the second loan. There were claims both in common law and in equity, and just so that you see the structure of the judgment, we go to page 1493. You'll see that his lordship is dealing there with the claims at common law, and then at 1496 the judgment picks up the claims in equity. And then if we go on under that heading to page 1499, we get to the heading breach of fiduciary duty. And the first part here, we don't need to dwell on it, but just to make sense of what then follows, the first issue his lordship was dealing with there was whether or not the duty to use reasonable skill and care as owed by a fiduciary was a fiduciary duty. he explains that it was a duty owed by a fiduciary, but not a fiduciary duty. If we could just pick it up over the page, page 1500, at just between F and G, there's a three-line paragraph beginning, "In my judgment, this is not just a question of semantics. It goes to the very heart of the concept of breach of fiduciary duty and the availability of equitable remedies. Although the remedy which equity makes available for breach of the equitable duty of skill and care is equitable compensation rather than damages, this is merely the product of history, and in this context is, in my opinion, a distinction without a difference. Equitable compensation for breach of the duty of skill and care resembles common law damages, in that it is awarded by way of compensation to the plaintiff for his loss. There is no reason, in principle, why the common law rules of causation, remoteness of damage, and measure of damages should not be applied by analogy in such a case. It should not be confused with equitable compensation for breach of fiduciary duty, which may be awarded in lieu of rescission or specific restitution." I simply wanted to draw that to your attention because part of my learned friend's case is based on trying to effectively try and erode distinctions between different remedies. The principled approach that Lord Justice Millett takes there is in our submission a helpful introduction to that thread. And then at the top of the next page is the passage that it is most often cited. This leaves those duties which are special to fiduciaries and which attract those remedies which are peculiar to the equitable jurisdiction and are primarily restitutionary or restorative rather than compensatory. A fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter, in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. This core liability has several facets. A fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interest may conflict. And when we come to the debate about a no-profit rule and a no-conflict rule, it is striking in our submission that His Lordship identified those two facets, as he calls them, separately. Not act for his own benefit or the benefit of a third person without the informed consent of his principal. And then he adds it's not intended to be an exhaustive list. So we do urge, and there's nothing remotely controversial or new, but we do urge on you the significance of the fact that the fiduciary relationship is founded on the obligation of one to act for and on behalf of another in a particular matter in circumstances giving rise to a relationship of trust and confidence, and the entitlement of the principal to this single-minded loyalty of his fiduciary. And with that as the foundation of the fiduciary relationship, we are just going back to our case at paragraph 14. We do suggest that it is an inevitable consequence of the relationship that the fiduciary must account to the principal for what he has done with the fund's assets, and we suggest that an account is not a remedy and does not necessarily respond to a wrong. And you'll have seen that we cite, in fact, a Hong Kong decision, but again, Lord Millett, as he had become in Libertarian. And again, it may be helpful just to turn that up. It's footnote 31. So Libertarian is at page 2934. Again, just to note, yet another decision in a purely commercial context, which caused the court no trouble whatsoever in applying the principles with which we are dealing. The issue was that a Mr. Woods was the principal. Mr. Woods, yes, Mr. Woods was the principal, and he thought shares were being acquired for his own benefit. Mr. Hall, the defendant, preferred them to be treated as beneficially owned by himself. And there was a dispute between them. That was just the context. Lord Millett's judgment is right at the end, at page 2979. And if we just pick it up at 167, paragraph 167 on 2979, Lord Millett says, it's often said that the primary remedy for breach of trust or fiduciary duty is an order for an account. I just emphasise all fiduciary duty simply because it underlines the point that the judge is not here talking about conventional trusts. He is talking generally about relationships which give rise to fiduciary duties. It is often said that the primary remedy for breach of trust or fiduciary duty is an order for an account, but this is an abbreviated and potentially misleading statement of the true position. In the first place, an account is not a remedy for wrong. Trustees and most fiduciaries are accounting parties, and their beneficiaries or principals do not have to prove that there has been a breach of trust or fiduciary duty in order to obtain an order for account. Once the trust or fiduciary relationship is established or conceded, the beneficiary or principal is entitled to an account as of right. Although, like all equitable remedies, an order for an account is discretionary, in making the order, the court is not granting a remedy for wrong, but enforcing performance of an obligation. I won't read the rest of it, but the analysis continues through to the end of paragraph 171. And
that can't always be true, though, can it? It seems to me in this case it isn't true because the fiduciary relationship had ended when the profits were made. There wasn't an ongoing relationship in the course of which an account could be sought.
At the time, no, that is absolutely true. The obligation to account arose from the pre-existing fiduciary relationship. No, you're right on the temporal point. Yes. Going back
but you would presumably say that some kind of feedback. A fiduciary doesn't necessarily escape entirely from an accounting obligation on the day he ceases to be a fiduciary.
Absolutely.
Because he's got to divest himself, quite apart from anything else, of all or any property or benefits which may have come his way while he was...
Exactly. The obligation, it results from the fiduciary relationship, not the question of when the account is asked for.
Yeah.
But so then are you saying that in this situation where the fiduciary relationship has ended, the account becomes a remedy, or are you saying there's some long-lasting post-trust obligation to account in the way that Lord Millett says here?
We would suggest that the obligation to account arises from the fiduciary relationship, and it doesn't become a remedy simply because that relationship has ended. The remedy that may be ordered ultimately, as this lordship goes on to point out, is that if, on the taking of the account, it emerges that the fiduciary is sitting on undisclosed, unauthorised profits, then the remedy is the order to pay them over. But the obligation to account is the obligation which is incurred because of the status of the person as a fiduciary.
Right, so even after the end of the fiduciary relationship, the principal is entitled to ask for an account without having to show that there's been a breach or wrongdoing.
Absolutely.
Mr. Crowe, I do think there's a scope for confusion and muddle here, because supposing a director of a company resigns, the company doesn't have a right to an order for an account by the director unless it can show that the director at some stage had property of the company in his hands. I mean, it's slightly different with a trustee because the trustee has legal ownership of the assets. But in a broader range of fiduciary relationships, that's not the case. There is a real sense of confusion here. I mean, I put this to Lord Wolfson yesterday. In the context in which we're talking, it is the fact that the appellants in this case had received profits. Which led to a liability to account and for the need for a taking of accounts, which, as I said, would not always be necessary. So I think there's a danger of confusing the position of the full trustee or the fiduciary that has indeterminate amount of assets in their hands with this sort of case where one's saying, look, you the defendants, have earned profits and you must account for them.
Yes. Well, I'm grateful for that clarification. It is the case that there will be nothing to account for if a director has resigned and has no assets. So, simply as a matter of fact, there is nothing to account for.
Quite, and the court would not order an account.
And the court would not direct. It must be fact-driven. Particularly in relation to relationships which have terminated. I entirely agree with that.
Yes, but it is the possession of the profits that changes a director from a non-custodial fiduciary into a custodial fiduciary in the sense that he has acquired something that needs to be accounted to the principal.
Absolutely.
But if the claimants here had just brought an action against the defendants saying, give us an account of the profits that you've made in your Honeywell companies, and had not in that claim alleged any breach of fiduciary duty by them, are you saying that they would have been entitled as a matter of law, as a matter of equity, to an account without needing to show a breach? Or?
Well, that trespasses into an area with which this appeal isn't concerned, which is the whole area covered by the Phase 1 judgment as to the extent to which a combination of disloyalty before the termination of a fiduciary relationship combined with the exploitation of a business opportunity afterwards and then the receipt of profits afterwards is capable of giving rise to a claim for disgorgement of the profits. But the analysis of what sort of nexus, so to speak, there needs to be between the pre-termination misconduct and the post-termination exploitation is not something that is part of this appeal.
Yes, but you took us to this statement by Lord Millett to say this is a primary duty, not a remedy, and I think what we're trying to explore is whether in these circumstances that is still correct.
It is correct because it's so long as
It's not how the judge approached it. She approached it on the basis of a passage Lord Justice Ricks we were shown yesterday in a case called Foster Bryant, where he said that when the relationship ends, there's no fiduciary duties owed after that point, but what has to be shown is the causal connection between a breach which had occurred up to the time of resignation and a later profit.
Yes. Well, that on the facts of a case where there is post-termination receipt,
which is our case.
Which is our case. Clearly, one of the issues is going to be that the extent to which the receipt does, so to speak, trigger the obligation to account. But the degree of connection between the pre-resignation or pre-termination conduct and the exploitation of the business opportunity afterwards is not one of the issues that needs to be explored in the circumstances of this case. But certainly not in the context of this appeal, because it simply isn't the subject matter of the appeal. The obligation...
I thought that was the subject matter of the appeal, in the sense that what's being criticised is the currently established test, at least at Court of Appeal, that there needs to be a connection or nexus between the breach and the profit, but not one involving causation, whereas they say what there needs to be established between the breach and the profit is a but-for causation.
The issue is indeed the extent to which the existing test, which is whether there's a sufficient connection between, we would say, the scope of the fiduciary duty and the profit, should be replaced by a test of but-for.
Is what you're saying that the interstices of the presence or absence of a sufficient connection isn't what the appeal's about, it's whether the whole test should be thrown away and replaced by another one?
Exactly so. And there is a difference between the question in this appeal, which is, should the sufficient connection between the scope of the duty and the profit be replaced by a but-for test on the one hand, and the separate question as to the nature of the nexus between misconduct during a fiduciary relationship and post-fiduciary relationship receipt of profits. That's the issue that's not in front of you. But that's the issue that I think I'm being asked about at the moment.
Yeah. I mean, I think it's in your case where you boldly say an account is not a remedy, and then you say, well, it's not a remedy for a wrong. In a sense, you don't really need those points, do you? I mean, we could argue all day whether an account is or is not a remedy. It depends on your definition of remedy. It seems to me that paragraph 14 perhaps states the case that you need to put somewhat too high, if I might put it that way. Do you think that's a fair point?
I absolutely agree, and it was going to be my last point on this section, that we don't need to establish the point that we're currently addressing you on in order to win, because the issue, as entirely correctly identified by Lord Briggs, is the nature of the nexus between the scope of the duty or the breach of the duty and the profit. So in order to win, we don't have to prove this point. The only reason I'm exploring it is that there are a number of stages at which we could win. If it is the right analysis that an account of profits is an obligation and not a remedy, and it is not dependent on the establishment of a prior breach, then the line, in a sense, the approach that Malone and Friend is suggesting, that there has to be a causative link tested on the but-for test between a breach of duty and a profit, isn't even a question that arises analytically.
But it's a bit like, I mean, if I might draw an analogy, there's long been arguments about whether specific performance is a remedy for breach of contract, or is a debt claim a remedy for a breach of contract, or are they really just following through primary obligations and no need for a breach? It seems to me that the account is somewhat analogous to that. And one might say, one could argue it both ways, actually, but it shouldn't ultimately, I wouldn't have thought, make any difference to the end result. So even if you say, oh, if it's not a remedy for a breach, then but-for causation is obviously out of the window. I'm not even sure that necessarily follows, but I think I would want to say, well, that may be one way of looking at it, but let's have a look at the other route and see where that gets us.
Well, I'm entirely content, and we absolutely are going to do that, but I just want to try and lay out as many different routes to dismissing the appeal as were available.
I think another way, perhaps, I think saying what Lord Burrows is saying, is you can't escape the causal question by characterising it as a duty rather than a remedy, because one way or another events that occur during the relationship between the defendants and the claimants, and then the defendants later make some profits, and you've got to connect those two up in order to win. And the question is, what's the connection?
I entirely accept that. I mean, having laid out the stall on this, your Lordship clearly got the point. Whether one calls it causal or not, you're absolutely right. We are talking about what is the connection. Could I just finish, because we haven't actually spent a lot of time looking either at Regal Hastings or Boardman and Phipps.
Can I quickly put to you, Lord Wolfson accepted yesterday that if a fiduciary derives a profit from the fiduciary relationship which has not been authorised by the principal, then he holds that profit on behalf of the principal and must account for it.
Yeah.
And that will be the case even if by the time he receives the profit, he has ended the fiduciary relationship.
Yes, absolutely.
So the duty to account in the first place is not dependent on a breach, because it's rather the unauthorised nature of the profit derived from the relationship.
Exactly.
And secondly, the duty can continue, notwithstanding that the fiduciary relationship itself has come to an end.
100%. And if it's of any help, I'm just going to take you to a couple of very short passages in Regal Hastings and in Boardman and Phipps that make those points. Not the temporal point.
Just before you do, can I just build out slightly on Lord Breed's point to you? You could have a fiduciary who behaves in an exemplary fashion up until the date of his retirement, but who thereafter receives something which, upon analysis, turns out to be an unauthorised profit. He'll be accountable for it, even though you can't pin him with some breach of fiduciary duty before he left.
100%.
That's as I think I understand where Lord Reed is going.
Yeah, absolutely.
I may merely have repeated it, but...
It's always good hearing things twice. Just a couple of short passages, as I say, from Regal and Boardman and Phipps. So Regal, starting at page 2245. The first passage at 2248 in the speech of Lord Sankey, just above letter G, as to the duties and liabilities of those occupying such a fiduciary position, a number of cases are cited to us which were not brought to the attention of the trial judge. In my view, the respondents were in a fiduciary position and their liability to account does not depend upon proof of mala fides. The general rule in equity is that no one who has duties of a fiduciary nature to perform is allowed to enter into engagements in which he has or can have a personal interest conflicting with the interests of those whom he is bound to protect. If he holds any property so acquired as trustee, he's bound to account for it to his Setiquet trust. And then if we go on to page 2254 in the speech of Lord Russell, 2254 between E and F. Nevertheless, they may be liable to account for the profits which they have made if, while standing in a fiduciary relationship to Regal, they have by reason and in course of that fiduciary relationship made a profit. That, of course, doesn't touch on the temporal point that we're dealing with, but it identifies the basis of the liability to disgorge profits as being the fiduciary relationship, not a breach of trust. And then page 22...
Just pausing there, by reason and in course of might be added to our little list of connectors.
Yeah.
The first bit, by reason of having, on the face of it, some sort of causative feel about it, although the second, in course of, not necessarily.
No, indeed, no. But, I mean, and none of these are clearly statutory definitions.
No, but where you see very eminent judges using them to explain something, it may be worth dwelling on them.
Yeah, for sure. And then at page 2660, letter F. In the result, I am of opinion that the directors standing in a fiduciary relationship to Regal in regard to the exercise of their powers as directors and having obtained these shares by reason and only by reason of the fact that they were directors of Regal and in the course of the execution of that office are accountable for the profits which they have made out of them. Again, not because of any breach of duty on their part. And then at page 2264, we move on to Lord Macmillan. My Lords, the real question for decision in this appeal seems unfortunately to have been somewhat obscured by the course of the arguments before the trial judge and to some extent also in the Court of Appeal. The issue, as it was formulated before your Lordships, was not whether the directors of Regal had acted in bad faith. Their bona fides was not questioned, nor was it whether they had acted in breach of their duty. They were not said to have done anything wrong. The sole ground on which it was sought to render them accountable was that by being directors of the plaintiff company and therefore in a fiduciary relationship to it, they entered in the course of their management into a transaction in which they utilised the position and knowledge possessed by them in virtue of their office as directors, and that the transaction resulted in a profit to themselves. So he says in terms, it's not based on doing anything wrong. And then finally at page 2270...
Well, I'm just adding to the list at the end of that paragraph, accountability for any profit if it was by reason and in virtue of fiduciary office.
Yeah. And it goes on in the next paragraph. The equitable doctrine invoked is one of the most deeply rooted in our law, amply illustrated by the authoritative decisions cited by Lord Russell.
Which page, sorry?
Sorry, I was, my Lord Reid just took me back to the end of the passage on 2264, and I was just reading the short passage D and E,
sorry,
which ends with a quotation from work from the late 18th century, telling us that equity prohibits a trustee from making any profit by his management directly or indirectly. And then finally,
a case where the defendants were in office as directors at the time they obtained their profit, which explains, I think, the language used by all their lordships.
Absolutely.
And your principal point here is there's no need for any wrongdoing. It's the fact of the making of the profit.
Exactly so. And then at page 2270, we're now with Lord Porter, just at letter B. To treat the problem in this way is, in my view, to look at it as involving a claim for negligence or misfeasance and to neglect the wider aspect. Directors, no doubt, are not trustees, but they occupy fiduciary position towards the company whose board they form. Their liability in this respect does not depend upon breach of duty, but upon the proposition that a director must not make a profit out of property acquired by reason of his relationship to the company of which he is a director. And similarly, if we can just pick up some related passages in Boardman and Phipps, which work from that. So starting at page 1382. Is the report, and if we pick it up, just a few short passages. First, at 1437 in the speech of Lord Cohen, you'll see just below letter C on 1437. He cites passages Regal, Hastings and Gulliver. We don't need to reread that, but having cited all that, if we turn over the page...
Sorry, I've got the wrong page.
I'm so sorry, my Lord. I'm on page 1437.
Thank you. My fault.
And at letter C, Lord Cohen cites Regal, Hastings and Gulliver and quotes several passages from that. And if we go over to page 1438, between C and D, he quotes Lord Russell. And speaking of Lord Russell, he says, he goes on to consider whether the 4 directors were in a fiduciary relationship to Regal and concludes that they were. Accordingly, they were held accountable. And so clearly Lord Cohen's understanding, and our submission is entirely correct understanding of Regal, is that the liability was founded on the status of the director, hence the word accordingly, not on any breach of duty as such.
Well, it has to be read against the background that they've acquired the shares by reason of their position as director.
Exactly, which is the point I will get to. But I won't read the whole of the rest of that, but it carries on really over to page 1439 at B. And then, again, very briefly, 1441, Lord Hodson, just below letter A, the second paragraph, the proposition of law involved in this case is that no person standing in a fiduciary position when a demand is made upon him by the person to whom he stands in the fiduciary relationship to account for profits acquired by him by reason of his fiduciary position and by reason of the opportunity and the knowledge, or either, resulting from it, is entitled to defeat the claim upon any ground, save that he made the profits with the knowledge and assent of the other person. And
that form of words referring to by reason of the position and by reason of the opportunity and knowledge, that's the same form as I saw a minute or two ago in one of the earlier speeches. So it seems to have been a form that the lordships were using.
Yes. Yes, I think that's right.
And that comes out of Regal.
Yeah, absolutely.
Where it, in the end, although they start by reason, it's only part of the explanation. It becomes the main one during the course of the judgments.
I've got it. It's Lord Wright in Regal being cited at page 1437 at the foot of letter G.
Yeah.
Yes, the opportunity and the knowledge, or either resulting from it. Yes, so he's sort of quoting without inverted commas the approach taken before.
Yeah.
And so just moving forward, page 1453, we're in the speech of Lord Guest. At the bottom of the page, 7 lines up, just above letter G, there's a sentence beginning, in the present case. In the present case, the knowledge and information obtained by Boardman was obtained in the course of the fiduciary position in which he had placed himself. The only defence available to a person in such a fiduciary position is that he made the profits with the knowledge and assent of the trustees. It is not contended that the trustees had such knowledge or gave such consent. And then finally, page 1459, in the speech of Lord Upjohn, just above letter D, rules of equity have to be applied to such a great diversity of circumstances that they can be stated only in the most general terms. I just pause there because one of the complaints made in the grounds of appeal is that the current test is uncertain and insufficiently precise, and we will be urging those 2 and a bit lines of Lord Russell on you in answer to that, that the position cannot be otherwise because of the very reason given by Lord Russell, Lord Upjohn, I'm so sorry, thank you, the rules of equity can be stated only in the most general terms and applied with particular attention to the exact circumstances of each case. The relevant rule for the decision of this case is the fundamental rule of equity that a person in a fiduciary capacity must not make a profit out of his trust, which is part of the wider rule that a trustee must not place himself in a position where his duty and his interest may conflict. That part of the paragraph touches on the debate that we probably also don't need to have but is canvassed in some parts of the cases in this appeal as to whether the no profit rule and the no conflict rule are mutually exclusive, or whether one is part of the other. So I just draw that to your attention. But for the purposes of this stage of the argument, all I am seeking to draw to your attention is the fact that the rule, the fundamental rule of equity, is not based on establishing a breach, but it is based on the status of the person as a fiduciary.
What was said there in the first sentence that you referred us to, I think, was repeated by the board in New Zealand and Netherlands Society in Keys.
I think that is absolutely right, yeah.
Yes.
Yeah.
So emphasising that the rule has to be stated in very general terms and applied having regard to the particular circumstances.
I'm grateful.
Yes.
So that was all we wish to say. As my Lord Burrows has already probed, we don't need to win on that point, on the point that the is status-based rather than breach-based. We do have to, and obviously we will engage with the nexus question, the reasonable connection question. But if your ladyship and your lords were satisfied that the liability is status-based rather than breach-based, that does at least get to this point, that the relevant question is what is the appropriate nexus, what is the appropriate test between the profit that is earned and the duty that is owed. The question should not be what is the connection between the profit and the breach, because it is, as we say, a wrong premise to assume there has to be a breach in all cases. Yes, there was disloyal misconduct in this case, but we are talking about a general principle of law. So the relevant question the court is grappling with is what is the degree of connection between the profit that was earned and the scope of the duty that was owed. The relevant question should not be posed in terms of what is the connection between the profit and the breach, because that assumes that a breach is a prerequisite to triggering an accounting liability. So that brings us back to our case, just to keep more or less on track. Back to our case, paragraph 16, where we make the point that we've just touched on, that authorities do talk about a no profit rule or a no conflict rule. And we've just looked at the short passage in Boardman and Phipps, which suggests that the rule in relation to no profit is actually part of the no conflict rule. The alternative view from the New Zealand-Netherlands Society case is that the two are somehow equivalent to each other. As I say, it's not necessary, I think, for the purpose of this appeal to find an answer to the question whether they are distinct rules. There is a perfectly coherent argument for saying that there is a difference between them in this, that you can clearly act in breach of the no conflict rule without receiving a profit. You may act in the breach of the no conflict rule and generate a loss to the trust fund.
It's slightly harder to see how you can make an unauthorised profit if you haven't acted in breach of the no conflict rule, because the no conflict rule says you mustn't even go there.
Yeah. Well, as I say, I don't want to get too far down this rabbit hole, because I don't think we need to, but there is analysis from, I think it was Matthew Conaglan, who, looking at Keach and Sanford, says it's difficult actually to think about Keach and Sanford as a conflict case, because in taking the lease in his own name, the trustee wasn't in fact exercising a trustee power, So he was making a profit, but he wasn't, strictly speaking, he wasn't exercising a discretionary trustee power in doing so. And indeed, on the facts of the case, one of the striking features is that the trust couldn't take the benefit of the lease. So it is an interesting
the
point.
reason given by the Lord Chancellor for having a strict rule is that if there weren't such a strict rule, then no beneficiary would ever get a lease renewed.
Yeah, absolutely.
So he's envisaging we have to have the strict rule that applies in this case because of those cases.
Absolutely, and that will get us into the deterrence territory, if that's the right word. But yes, you're absolutely right, my lady. And as I say, it is a fact that from the very outset, this whole area of the law has been guided by fairly pragmatic considerations. And as I say, we would submit a very clear-sighted view of human nature and human nature's ability to deceive oneself into thinking one is really doing one's best for the beneficiary when one may well not be.
Mr. Crowe, do you say that this, if there is a distinction between no conflict and no profit, and I'm inclined to think that no conflict is a wider concept than no profit and largely includes no profit, but do you say that this case is a no conflict case or specifically a no profit case?
We will submit that, well, potentially two answers, in that if the two are mutually exclusive and one had to make an option for one or the other, we would say this is a breach of no profit, because a profit is received. And the only answer that the appellants have come up with is to say, oh, well, we only received the profit after the termination of the relationship.
Yes, I see.
And they critically say, and we would have made it anyway.
Well, they do also say that, but that's on a sort of slightly different point. Simply on the question as to whether it's no profit or no conflict. Yes, no profit or no conflict. We would submit that it is difficult to see how any receipt of an unauthorised profit can not be a breach of the no profit rule.
Well, that's why they can't be mutually exclusive.
Well,
if I, as a director, promote a company in which I have an interest to enter into a contract with the company, and it's not accepted by my colleagues that the transaction should be placed, I'm breaching a no conflict rule. If my colleagues place the contract, the company places the contract with the company in which I have this interest, then and I make a profit, I breach the no profit rule. One leads into the other.
Yes, absolutely.
I mean, you've got to have a profit for an account of profits to be on the agenda at all, don't you?
Yes.
Yes.
I mean, there'll be plenty of cases of a breach of the no conflict rule without a breach of the no profit rule. For example, you might be the trustee of another trust, and the arrangement was not in the interests of the first trust of which you're a trustee. You've got a conflict of interest and duty, or conflict of duties that might lead to the rescission of the contract. Yeah. There's no personal profit made by the trustee in that case.
Absolutely. The only reason I'm engaging in this at all is that there is a line, it wasn't developed orally, but there is a line of argument in Milan and Friends' written case to say that it matters to draw a distinction between no conflict and no profit cases because, and the refrain that it recurs in Milan and Friends' case is to say that in a no profit case there is a self-defining pool of assets which are the product of the breach of the duty. In his analysis, the duty being the duty not to make a profit. So his analysis, and this is part of, so the starting point, he says, is in a no profits case, there's a self-defining pool of assets, namely the assets received in breach of the no profit rule. He says his clients are in the no conflict category, and it's in that category, he says, that there is all the more call for a causation test, because the profits received in breach of the no conflict duty is somehow not self-defining. With respect, that argument isn't internally coherent, because even if no profit and no conflict are entirely separate rules, and if it is the case that there is a breach of the no profit rule, you still have to work out what are the profits received in breach of that rule. So it can't be said that there is a sort of a greater call for some kind of but-for causation test in relation to breaches of no conflict cases than there is in relation to no profits cases. And ultimately, having gone through quite a lot of argument as to try and differentiate between the two, ultimately, I think Melena Friend's argument does actually recognise that there does have to be an analysis of the question of what is the pool of assets in respect of which the liability arises. So, as I say, analytically, for the purpose of answering the issue in this appeal, you do not need to reach a firm view on whether these two rules are distinct or mutually exclusive. We would suggest that the better answer is that they can't be mutually exclusive. If it is necessary to analyse, to categorise the liability in this case, it must, in our submission, be a liability in relation to the no profits rule. As it happens, this wasn't really, I think, an issue that was explored at trial, because it didn't, at that stage, it just wasn't an issue that the trial judge was invited to rule on. As just said, you've got the references, the pleading relied on both an articulation of both the no profit and the no conflict rules as having been engaged, and that's paragraphs 96.3 and 96.5 of the amended particulars of claim, which is page 563. And the judgment below, the phase one judgment, did not differentiate between the two in finding liability, because, as I say, it's not a criticism of the judge, her ladyship wasn't asked to, and that's paragraphs 424 to 426 of the phase one judgment, page 396. Liability was duly found. As pleaded, we would suggest, and therefore both no profit and no conflict. As I say, even if the point is relevant and you considered it appropriate to express a view on the classification in this case, we would submit that the appellants' arguments that they're only liable under the no conflicts rule because, as a matter of chronology, they received the profits after they had ceased to be fiduciaries. That, in our submission, just doesn't contain any sort of analytical logic to it. A profit is received by somebody who owed fiduciary duties, and in our submission it is clear that that must be a receipt that engages the no profit rule. Can I just see if there's one paragraph that it would be helpful to look at? Yeah, it may be helpful just to sort of close off this before leaving it. We just look at page 316. Insofar as so this is in the 316 is in the phase one judgment, and her ladyship is at this stage analysing the question of law on the duration of fiduciary duties, and at paragraph 72 I think my learned friend read part of.
Yes.
It says, nonetheless, in order to prevent the emasculation of fiduciary duties, a fiduciary may be found to have breached fiduciary duties by reference to what he later does. Resignation will not avoid liability where the fiduciary uses for their own benefit property or information which they acquired while a fiduciary. This will be a breach of the no profit rule. Citing Snell Ultraframe, this ensures that he does not resign the fiduciary position in order to do what the fiduciary doctrine would otherwise bar the fiduciary from doing. And so in our submission, that analysis there of the law it is entirely correct, and applying it to this case would suggest that if the judge had been asked, her ladyship would have found that the receipt in this case engaged the no profit rule, not the no conflict rule. And so if a distinction does need to be drawn, we would suggest that that would be the right answer, and the answer that the judge either did or would have come to.
It's notable that the House of Lords, both in Regal Hastings and Phipps and Boardman, didn't feel the need to engage in this debate at all. We find no reference to either rule in those cases.
Well, we were shown Lord Upjohn's speech. He showed us where he did say one was a subset of the other.
Yeah.
Right.
Yeah, that's the first we've got.
It wasn't a sort of distinction they were seeking to draw.
There's certainly no.
And although this is all long before Lord Millett's single-minded loyalty encapsulation, it's easy to see how both those rules contribute to the avoidance of a departure from single-minded loyalty.
Absolutely. So I think we can then just revert to our case, paragraph 17, which just wraps up that section where we say that the consequence of a fiduciary making an unauthorised profit is that they are liable to disgorge the profit, consistent with the usage we have suggested. This is just maybe semantics, but it may also help to clarify one's thinking, to talk about the obligation to account for a profit and a liability to disgorge it. And we apprehend that gives some sort of that is offered in order to adhere to the analysis in Libertarian and elsewhere as to the nature of the obligation and the liability that's engaged. So we then move on in the next section of our case to look at the scope of the liability, and we offer a number of propositions that flow from the analysis that we've just put forward. So at 18.1, we suggest that the liability arises from the fact of the profit, and that it reflects the fiduciary relationship requiring undivided loyalty. And at 18.2, these are really just summary conclusions from what we've seen. The corollary is that the liability does not depend upon any dishonesty or bad faith. We've seen that clearly as expressed. 18.3, nor does the application of the rule depend upon demonstrating that the fiduciary obtained a benefit which it was his or her duty to obtain for the principal. That was one of the points expressly covered in the authorities we've seen. And 18.4, we do say that as a result, it provides the fiduciary of no defence to demonstrate either that they would have made the profit or some part of it, even if there had been no breach of fiduciary duty, and or that they would have been able to persuade the principal to permit them to retain some or all of the profit. If our analysis of the basis of the liability is correct, those consequences follow, because the liability to disgorge unauthorised profits springs from the receipt of unauthorised profits. It is not an answer to that liability to say, if the facts had been different, and if I had got authority, if I had asked for authority, I would have got it, because those aren't the facts. And the liability is triggered by the facts that have happened. The liability is triggered by the fact of an unauthorised profit being received. So, as a matter of analytical principle, we submit that introducing a but-for test would be inconsistent with the principles basis upon which the rule has developed. But it's more than that, because in our submission it is clear that the but-for test has been disavowed in the case law, and rightly so because of the principle. So the 2 points that we wish to urge on you are, first, that the current state of the law flows from the nature of the liability itself. It's not some sort of accidental construct of the case law. It flows from the structure of the liability, and it is reflected in the case law, which is the next point. One of my learned friend's opening remarks was initially to say that this wasn't a case in which he was going to be arguing that previous case law had been misunderstood. He was avowedly asking for a change in the law. But with respect, he then didn't pursue that line, because he did spend a considerable amount of time trying to persuade you that the disavowal of the but-for test is based on a misunderstanding of Regal, Hastings and Gulliver. He says that Murad misunderstood Regal, Hastings and Gulliver. Now, if we can just look at where he makes that assertion, he made it on his feet. He makes it in his case, his written case, at page 150. And at paragraph 33, he cites a passage from Lord Russell, I think, in Regal. The rule of equity, which insists on those who by use of a fiduciary position make a profit, being liable to account for that profit, in no way depends on fraud or absence of bona fides, or upon such questions or considerations as whether the profits would or should otherwise have gone to the plaintiff, or whether the profiteer was under a duty to obtain the source of the profit for the plaintiff, or whether he took a risk and acted as he did for the benefit of the plaintiff, or whether the plaintiff has in fact been damaged. That decision is followed in Boardman and Phipps, and he goes on to say, however, saying that it is not relevant to consider whether the principal could have made the profits for himself is not the same thing as saying that one cannot consider whether the fiduciary would have made them but for the breach. The former is justified because the inquiry is concerned with disgorgement of profit made by the defendant, not compensation for loss suffered by the plaintiff. By contrast, the hypothetical inquiry as to whether the fiduciary would have made the profit in any event is essential in order to determine whether the profit in question resulted or derived from the breach. And then he says that Lady Justice Arden in Murad wrongly took Regal reasoning it further, saying at 67, the fact that the fiduciary can show that that party, that's the claimant, would not have made the loss is, on the authority of Regal, an irrelevant consideration so far as an account of profits is concerned. Likewise, it follows in my judgment from the Regal case that it is no defence for a fiduciary to say that he would have made the profit even if there had been no breach of fiduciary duty, emphasis added. The latter part of the defendant's contend does not follow and is an unnecessary and incorrect gloss on the statement in Regal. Now, in our submission, that analysis is wrong, both because excluding the but-for causation test follows naturally from the principles basis upon which the liability to account for unauthorised profits is based, and it also, in our submission, follows from a correct analysis of the actual wording used in Regal, Hastings and Gulliver. And we submit that Murad does not involve either an extension or a misunderstanding of Regal, Hastings and Gulliver. Indeed, the passage that we have just seen quoted, and it was Lord Russell, the passage we just saw quoted from page 144. If one just goes on, if one just actually gets the Regal back out again at page, so it's page 2256. So 2255, sorry, is the passage that is quoted in my learned friend's case, letter G. If one then turns over, one sees at the top of page 2256, the liability arises from the mere fact of a profit having, in the stated circumstances, been made. The profiteer, however honest and well-intentioned, cannot escape the risk of being called upon to account. So in our submission, the very next sentence in Lord Russell's speech makes clear that Murad did not involve a misunderstanding, because Regal itself is expressly founded on the basis that the liability is triggered by the receipt of an unauthorised profit by somebody owing fiduciary duties, and it is therefore an irrelevance to inquire whether, if the facts had been different, the liability would have arisen. In a sense, the answer is always going to be...
follows. I mean, you've still got... It doesn't show that you should have to consider the but-for question, but you're still going to have to grapple at some point or other with the nature of the connection.
Indeed so.
It might or might not involve... I can see the arguments it doesn't, but I don't think you can just prove that by saying that, well, once you've got an unauthorised profit, you must account for it, of course, but only if you derived it by the right route.
Indeed so. Indeed so. That I entirely accept, but the sort of the slow accumulation of our analysis is intended to lead us to the point where the analysis of whether or not the reasonable connection test should now have incorporated into it a but-for causation test. Our submission ultimately, as you will have seen from our written case, is that introducing that, so the but-for test, would be inconsistent with the principled basis upon which the rule has developed. I absolutely agree, and I hope I don't appear to be sort of putting off engaging with the necessary connection test, what is actually being looked for. We will get to that in a couple of pages, the next page. We just wanted, as I say, to build up to it by looking at the principal basis and the case law that leads up to it. The only other thing, just on whether or not Regal Hastings has been misunderstood in Murad on this very point, is that it was our submission, and you'll have seen in our written case, is our submission that Regal was not making any new law in this regard. We cited the case of Brickenden, which is, we don't need to go back to it, my learned friend took you to it yesterday at page 2703 of the bundle, which makes this point that it's a matter of irrelevant speculation to inquire what would have happened but for. My learned friend says that there are, well, that on the facts, that case was a case involving a claim for loss rather than an account of profits. But in our submission, that authority remains good in relation to our fact situation, although in relation to equitable compensation, cases like Target and AIB have now moved on and they have adopted a different approach. Brickenden was decided clearly long before that, and there's no reason to consider that it isn't relevant law in relation to accounts of profits. My own friend also took you to Gray, not the Gray that the recent one, but the 1952 Gray and New Algarita Porcupine Mines, at page 2791. And that clearly makes exactly the same point, that it is an irrelevant inquiry. It's irrelevant speculation to ask whether the profit would have been earned but for the breach, and that is a case dealing with unauthorised profit. It is chronologically decided after Regal, Hastings and Gulliver, but it doesn't refer to it. So it can't be said that there was some sort of misunderstanding in the law flowing from Regal, because Gray and New Algarita is decided without reference to Regal, Hastings and Gulliver, applying exactly the same principle in our submission, and it's doing it, we would submit, consistently with the principled approach that we have urged on you. And as it happens, again, we haven't been to it, and I think in the interest of time I probably won't go to it, but IDC and Cooley makes exactly the same point, as it happens, by reference to Regal, Hastings and Gulliver, as did Murad. And just for your note, so that's IDC and Cooley at page 1860.
1860?
Yeah, 1860 at letter G.
Mr. Crowe, I just wanted to know whether you rely on what Lord Russell said in Regal Hastings at page 2261 in the bundle. Between letters A and B, where he says that they, the directors, had they wished, would have protected themselves by a resolution of the Regal Hastings shareholders in general meeting. In default of such approval, the liability to account must remain.
Yes.
I mention it because that's actually what Lady Justice Arden relied on in Murad.
Yes. I'm grateful, and absolutely so. I was going to come back to that in a slightly different context, because there's a sort of one of the threads running through my learned friend's submissions is that this is a very harsh rule, and part of our answer is it is not remotely harsh, because it merely precludes unauthorised profits, and there are very simple solutions to being found liable, which is to obtain authority. That is not necessarily in all cases, but that is...
And indeed, in Phipps and Boardman, both Lord Hodgson and Lord Guest, I think, said that was the only defence.
Yes, yes.
And although they may or may not have had a sort of but-for, we'd have made the profit anyway defence in mind...
They said what they said.
It covers it as a matter of language.
Yeah. Absolutely so.
But I thought your point was one doesn't see in the case law, in each case, an investigation as to whether that authority would have been forthcoming if it had been asked for.
Yes, that's right.
I mean, there are some cases like this one where it's blindingly obvious it wouldn't have been, no, but absolutely. There may have been other cases where if that was a test, or if one was looking at what would happen in the counterfactual world, that would be an investigation that you would need to undertake.
Absolutely. And it is just not addressed because, in our submission, it is an irrelevant speculation. So going back to our case at paragraph 18.5 on page 195 of the core bundle.
Just before leaving that passage in IDC and Cooley, there's some quite useful reflections on where the no conflict rule features in all this. Yes. From Miss Justice Roscoe, was he?
Yes, I mean, IDC is quite a useful sort of comparator because it's another departing fiduciary case.
Yeah.
So it does. Sorry, I didn't mean to sort of shut it down. It is illuminating, and we certainly commend it to you for that reason. So back to paragraph 18.5. on page 195, and just finishing off the sort of the consequences of the principled approach that we suggest that underlies the liability to account for unauthorised profits. We make the uncontroversial point in 18.5 that it's immaterial to inquire whether the profit would otherwise have gone to the principal. In other words, it doesn't matter if the result is to confer a benefit on the principal, which they would otherwise not have been able to reap. And
that was the case in Keach and Sanford.
Exactly so.
Yeah.
Exactly so. And that much has been clear. And we point out simply that it continues to apply with as much force today, as illustrated, for example, in the context of a fiduciary's duty to account for bribes or undisclosed commission. The liability there is clearly not based on any sort of assumption that the principal would have been entitled to the bribe. The reason that the agent or whoever it is held accountable for the bribe is that it represents a profit received which is unauthorised by the principal, not because it is taking from the principal a profit that the principal would otherwise have been able to obtain. And the liability in 18.6, the liability is to account for all unauthorised profits. And so paragraph 19 I would is simply an attempt to draw together where we've got that the liability to disgorge arises because it represents the unauthorised profit represents an unauthorised profit which has been acquired by a person who owes a duty to deal selflessly for someone else's benefit. And we then say that leaves the question which most nearly engages with the issue in this case, which is, well, what does a profit derive from, or however one expresses it, the fiduciary relationship? What is the necessary connection, the sufficient connection, and also to engage with the question of deterrence. So starting over the page with the section headed sufficient connection, the way the law is currently expressed is that the test that the court applies is whether the profit has a sufficient connection with the scope of the fiduciary duty that was engaged. And that is perhaps most recently and most clearly articulated in Gray and Global Energy at paragraphs 1 to 4 and 1 to 8. I won't go back to them because you've seen some of this quite recently. So paragraphs 1 to 4 and 1 to 8 at page 1653. And in Keystone, which we haven't gone to, but I don't think I need to expand particularly, but Keystone, paragraph 18, which is page 1867. So the test that has been articulated, as I say, is whether there is a sufficient connection.
That doesn't really tell you anything, does it?
Well,
saying it's got to be a good enough connection, whatever, but then the question is, well, what is sufficient?
What is sufficient? And as was said by Lord Upjohn, principles of equity can only be stated at the highest level of generality and then applied by reference to the circumstances of cases in hand. One of the points, and it may be just useful to go back, one of the points upon which the appeal was grounded, if we just look at the grounds of appeal at page 30 in this core bundle. And one looks at paragraphs 7 and 8. What is suggested is that this issue would have come up in Murad. Permission was refused in Murad to take it to the House of Lords, presumably because by contrast with a hypothetical case posited by later Justice Arden at paragraph 82, the defendants in that case, Mr. Al-Siraj, who had been found to be dishonest was an unattractive candidate to be the beneficiary of an alleviation of harsh consequences. As a result, the courts have since been operating in a state of confusion, and in anticipation of the sort of change referred to by Lady Justice Arden, paragraph 8, such uncertainty is undesirable, and in large commercial cases such as the present can add significantly to the cost of the litigation. So the appeal has partly been founded on the assertion that the sufficient connection test is uncertain and is creating difficulties. Our response to that is that there is simply no empirical evidence that the courts are struggling with this test.
Mind you, you did take us in both Regal and in Boardman and Phipps to dicta which were much more specific than simply saying a sufficient connection. We saw one member of the appellate committee after another in Regal using the expression by reason of the fiduciary relationship or by reason of and in the course of. And then we, in Boardman, we saw Lord Wright's, well, a citation of Lord Wright in Regal, which is then adopted, saying, by profits acquired by reason of his fiduciary position and by reason of the opportunity and the knowledge or either resulting from it.
Yes.
So, if one can find more specific tests, if you like, or at least guidance.
Well, we were going to offer that as the answer, yes. I mean, without being too sort of, taxonomic about it, we do suggest that the sufficient connection label is the test. Absolutely, guidance can be found in the sort of expressions that your Lordship has indicated. But again, echoing what Lord Upjohn said, because one cannot foresee and one cannot in equity sort of legislate for all the factual circumstances in which these issues are likely to arise in practice. Yeah. It is not possible to define in advance exhaustively what the connecting factors must be. Yeah.
And well, I find that a very difficult submission, I have to say. That sounds like we don't have tests anywhere in the law because it's all fact dependent. I mean, why do you think equity is so different from the common law in this? But more specifically, your case would be fleshed out because you also accept your paragraph 21 that the test of is in the course of or by means of,
yeah,
or out of the relationship. If we're struggling with sufficient connection, presumably you would tell us, well, go back to your previous sentence.
Yes, absolutely.
I mean, Lord Upjohn himself, who knew a thing or two about equity, he does say, as you say, that rules of equity can be stated only in the most general terms. But his next sentence is, the relevant rule for the decision of this case is the fundamental rule of equity that a person in a fiduciary capacity must not make a profit out of his trust.
Yes.
That's much more precise than simply speaking of a sufficient connection. But mustn't make a profit out of his trust or his fiduciary relationship.
I mean, the causal connection is between the performance of the role of fiduciary and the profit that you make, isn't it? There is, if you like, a but-for test, because if you would have made the profit quite irrespective of whether you've been a fiduciary, say because you were buying tickets on the lottery or something, then it's not a profit out of your fiduciary position.
Well, as your Lordship said yesterday at a relatively early stage, it's difficult entirely to avoid some sort of causal thinking, because yes, absolutely, the profit does have to have a sufficient connection. It has to flow from, however one wants to express it. And actually, we are entirely agnostic as to what your Lordships and your Ladyship regard as the test and what you regard as guidance. and whether or not this court considers it appropriate to define more precisely what is already there.
But I mean, if it's going to be a causal connection, then you know at least that some factors must be irrelevant to that, which might be relevant if it was all well, is it fair and just in all the circumstances?
Yes.
So the causal connection cannot be affected by the dishonesty or bad faith or the honesty or good faith of the fiduciary. That cannot affect the causal link. So one puts on one side those because it has to be a causal link and not just a fair in all the circumstances test. But is there anything else that you exclude from the equation because it is a causal link?
The only reason that we have expressed some sort of diffidence about adopting the word causal is that one immediately sort of drifts towards the common law concept that one is accustomed to in tortious and contractual damages with causation, which is a sort of well-established set of rules which involve principles which we say are wholly inapplicable here, which is why we apprehend that the sufficient connection test is the label that has been used. It is, I suspect, a matter of taste as to whether one needs another label, such as a causal connection, to add to the phrases that, for example, my Lord Reid has already identified as existing in the case law.
I wonder what seems to me objectionable in the defendant's analysis here is that they want to postulate a particular hypothesis about what would have happened if there hadn't been a breach, let's call it that.
Yeah.
And they want to suppose that the fiduciary would have still attempted to procure the same self-interested advantage, but without stepping outside the confines of their fiduciary role.
Yeah.
That's a particular counterfactual hypothesis.
Yeah.
There's no need to pose that as your test of causation, but that seems to be what the real mischief is of their approach, to my mind.
Well, I'm grateful, and I hope your Lordship remains of that mind.
Can I see if I can come up with a sort of leaboard that prevents the drift which you're concerned about? You're saying that the moment you start using the word causation, you drift off into general common law concepts of causation and end up hard on our bank called but for. If one goes back to Lord Upjohn, he says you apply the general rule with particular attention to the exact circumstances. And I wonder if what he might have objected to was doing other than, when using words like as a result of or out of, he's looking at what actually happened. Did that profit actually derive as a result of the fact that the fiduciary who made it was a fiduciary with the information which he got as such? He's not looking or speculating outside the exact facts about a counterfactual. And it's only if you get into the counterfactual that a but-for concept gathers any kind of momentum. Indeed, it doesn't work otherwise. It requires you to do the counterfactual.
Yeah, absolutely.
Yes, if you stand back and you ask yourself, did the fiduciary acquire the knowledge which led to the profit in the course of his performance of his fiduciary duties?
Yeah.
I mean, there is a causal relationship there, but it's nothing to do with tort causation or but-for causation.
Yes. Well, as I say,
So one doesn't get to the mountaineer's knee
We certainly don't want that.
idea. Well, if he hadn't gone mountaineering, then he wouldn't have hurt his knee. And if the doctor, what was the? Because those are also scope of duty cases.
Yeah.
What is it that the doctor examining his knee promised to do?
Yeah.
And it's the same with contributory negligence. Yes, if I'd worn my seatbelt, I might not have suffered any injury at all, but that doesn't mean my contributory negligence is 100%. I mean, all these are very context specific. So I think what we're looking to you, what I'm looking to you for, is what do you say the context of this context requires of the causation test?
Yes. Yes, I think we said something in AIB about, I borrowed probably from Chief Justice McLaughlin in Canson about how the approach to causation and equity isn't necessarily the same as, or may not be the same in every context in equity, and it's certainly not the same as in the common law.
Yeah, absolutely. Well, as I say, we're all on this side of the court, we're just almost spectators rather than litigants in relation to the question how much more particularity this court chooses to give to the existing test. The only function we are attempting to fulfill in front of you is to resist the suggestion that the existing test is so uncertain, so unclear, and is generating such problems in practice, which is the point I took you to the grounds of appeal for, that it has to be changed. It doesn't have to be changed. If the court finds a way of clarifying the existing rule, I'm sure as a mere practitioner I should be grateful, and those behind us will also be grateful. Our only function is not to sort of urge some perfect drafting of the existing rule, but simply to defend its integrity against the allegation that it is so uncertain and is creating such confusion, as the grounds of appeal suggest, that it needs to be replaced. And in our submission, there simply isn't any basis for advancing that as a ground for allowing this appeal.
Well, given the need to be sensitive to different factual circumstances, is there anything wrong with what you say in the first sentence of paragraph 21 of your written case? The test is if the profits are made out of the relationship or in the course and by means of the relationship. Isn't that sufficient?
I think I would probably not be thanked by my own team if I suggested there was anything wrong in the first sentence of our case.
But I think one has to go a bit further, as my Lord Legate was saying, I think, that you say you look at what happened and you don't go beyond that to look at other factors such as honesty, dishonesty, good faith, bad faith, or you don't speculate as to what might have happened if they'd asked for authorisation, if they'd resigned sooner, if they'd done all sorts of things.
Yeah.
Is that how you...
But the out of the relationship does the job, doesn't it?
Well,
I mean, if we're thinking of where doesn't that test work, if we were to think of a fiduciary who makes unauthorised profit, that is, while a fiduciary, that is, during the, in the evening, goes down to the betting shop and makes a profit using his own money, we would immediately say, well, is that unauthorised profit out of the relationship? Plainly not.
Indeed.
And that's what we're trying to cut out, isn't it? So it's the source of the profit is the fiduciary relationship. And isn't that what people call attributable to
or sufficiently
the relationship
with?
But I mean,
what do you say about the Singapore case? I'd be interested to know, because that is the one where the directors get their remuneration having voted shares wrongly in favour of their remuneration, but they still would have got that remuneration even if they voted the shares the other way.
Yeah, well,
now they we're not speculating about anything they would have done differently. We're just saying that there wasn't the right causal connection, or that's what the Singapore court was saying.
Yeah.
Do you say that was wrong or right?
Well, we submit that actually you could have come to exactly that outcome without adopting the legal analysis that the court chose to go down. I absolutely accept that they say they are adopting a but-for test, but actually what they were doing was what my Lord Briggs described, I think, simply counting the votes. They weren't speculating as to something that hadn't happened. They were simply taking account of something that had happened, namely that the other shareholders had voted in favour of the remuneration and that the remuneration was paid for that reason. And so it was on that basis that the outcome flowed.
You could tweak the facts a bit and say, suppose they'd gone round to all the other shareholders and said, please do vote for me to have this very generous package. Then you might be in a slightly different situation, but I don't know whether on the facts they...
No, well, my reading of the case is that wasn't, and as your ladyship says, that would involve tweaking the facts. So, but I think our answer is, in a sense, we have to accept, as a matter of analysis, the court does say it's adopting a but-for test in that judgment. I mean, you can do with that what you will, but as a matter of substance, the outcome doesn't involve the kind of speculation as to facts that haven't happened that Merlin Friend is urging on you.
It's factual rather than counterfactual.
Yeah.
Well,
you can express it as a counterfactual, because you can say if they had not voted the shares in their favour, the outcome would have been the same. What it doesn't involve is postulating them having done some different action, which then might have led to another result favourable to them, but not quite so favourable.
Mr. Crowe, on the facts of the Singapore case, I thought from looking at it briefly when we were taken to it yesterday, that the trustee or trustees were already in their own right directors of the company.
Yes, they were.
And the notable thing there is it wasn't a question of going for consent to the beneficiaries of the trust. It was relied on the shareholders.
Yeah.
And that, I think, is because they were already directors in their own right.
Yes.
I think the case would have been different if they had only become directors because they were trustees of the trust holding a substantial shareholding. In those circumstances, I don't think the shareholder vote would have been enough. They probably would then have required the approval of the beneficiaries to retain their directors' remuneration.
With respect, I agree on the understanding of the facts, and I agree with the analysis that your lordship's just.
It's just a quite different case, which at the moment I think is simply not analogous to what we're having to consider here.
No.
Yeah. I mean, I think we'd better let you make some progress.
No, it's obviously helpful to know what's troubling the court. Where we were, we've got as far as page 11 of our case. And the point we were simply going to make, and in a sense I've anticipated it already. As I say, we're not positively advocating for any greater clarity than perhaps it already exists by reference to the material quoted in the first sentence of paragraph 21. The only argument we're advancing in this appeal is to meet the allegation from the other side that the existing test is so uncertain that it needs to be abandoned. And the only other point we're going to make in that context is that one of the peculiarities of the appeal is that the appellants appear to be suggesting that the sufficient connection test is in fact a form of remoteness, and it should survive their proposed recasting of the law. If one goes in their case, paragraph 7.3, so page 140 of the core bundle, you'll see, by reference to the side heading of remoteness test, there should continue to be a remoteness test in relation to all breaches of fiduciary duty, limiting the account so as to exclude profits which are not sufficiently connected to the breach. Or again, such a test could apply in the case of no conflict, alternatively honest breaches. So one of the peculiarities of the appellant's argument is to say that the sufficient connection test is so incoherent and uncertain that it needs to be abandoned as the sort of causal link, if you wish. But it is sufficiently certain and clear to survive as a useful test in relation to remoteness. And in our submission, where an appellant comes in front of this court urging this court to abandon a very long line of the highest authority, and its own argument is internally inconsistent in that way. It should give you pause for thought as to whether the appeal should be allowed.
But you do need some kind of endpoint, don't you? When you have a diversion of a business opportunity, that the director sets up his own company. By the time the case comes to trial, that company's been going for 2, 3, 4 years, and it has every sign of going forward. You can't say, well, you fiduciary, you've got to keep working on this opportunity and just keep sending your profits over to me ad infinitum. So what is the end point there?
Well, sorry, my lady, I probably didn't make my point sufficiently clear. We're not suggesting that the liability of a fiduciary in that kind of situation is completely open-ended and indefinite in duration.
So you accept a remoteness test.
Yes.
All you're saying is it's totally incoherent to say sufficient connection is inadequate for one purpose but perfectly adequate for another.
Exactly.
So you say it's the remoteness test that puts the end date to that.
If that's the if remoteness is a useful label to apply to that concept, yes. But it is articulated in the current law through the application of the sufficient connection test. And as my learned friend fairly conceded, that was applied on the facts of this case, because some of the profits that were generated were regarded as not being sufficiently connected.
But that wasn't a temporal.
That wasn't a purely temporal point. No, I agree. And in some cases, and it may be that Australian case, Warman and Dwyer, can be best analysed as a sort of temporal remoteness cut-off. But that, again, that's got nothing to do with the issue that the appellant's trying to urge on you, which is that there has to be a but-for causation test in the first place. That's sort of an end stop, a long stop. Again, we are sort of entirely agnostic as to how that is articulated. We don't think that the existing law poses any problems at all. I was just going to spend a couple of moments because echoing Lord Upjohn's observation that statements of principle and equity need and can only be expressed at a relatively high level of generality, and that it is impossible to sort of draft an exhaustive test, because the outcomes must be responsive to the facts in every case. And I take my Lord Legate's suggestion, and indeed my Lord Burroughs' observation, that there have to be principles and guidance, but there have been repeated expressions of the need to maintain flexibility and responsiveness to the circumstances of each case. Now, I just wanted to spend a couple of moments looking at that. There's a case called Reed Jarvis, which you may have seen mentioned in the footnotes, which is, in fact, coincidentally, Mr. Justice Upjohn earlier in his judicial career. If we just look very briefly at that, which is at page 1848. This was the case starts at 1843, and it was a case about a tobacconist newsagent that had to be closed because of bomb damage, and it was operated by a person who then died, and one of the executors then opened a replacement business very nearby, and the question arose as to whether the executor who was running the sort of replacement business literally around the corner was accountable for the entirety of the profits of the new business. And Mr. Justice Upjohn, if you look at page 1848, he says right at the top of the page, what then is the proper method of assessing the accountability? Counsel for the defendant submits that one must look to see what is pleaded and what has been proved at the trial. One must then take those assets of the estate, or the benefits which have been so pleaded and proved at the hearing to have flowed to the defendant by reason of her position as a trustee of the estate, and value those benefits. counsel for the plaintiff says, on the other hand, that that would be an impossible inquiry and that one must make the defendant accountable for the whole of the business and its profits, making allowances for the time, energy and skill that the defendant has expended, the assets she has brought in, the testator's debts that she has paid, and, of course, the mother's annuity. No authority is precisely in point. Regal, so strongly relied upon by the plaintiffs, although containing some helpful observations on the general principle, certainly does not cover this case. And then he says this: I do not think it is possible to lay down any general rule in the context in relation to businesses beyond the general principle already stated that a trustee may not make a profit out of his trust. So your lordships will, and your ladyship will see there that the twin points, in a sense, that the concept is a profit out of the trust, but beyond that, it's impossible to lay down general rules. And then a few lines below that, after an example, his lordship says, each case must depend on its own facts, and the form of inquiry which ought to be directed must vary according to the circumstances.
So what did they decide at the end? Which was it? It was the second. Was it the second?
I have to admit, I've temporarily forgotten which side of the line.
I think it was the first approach, because the business was essentially a replica of the original business, and so you could take it that everything was included unless it was excluded.
Yeah. No, that you're right. You're quite right, Lord. I don't think we need to go back. Yes, we've seen Boardman and Phipps. There's some observations in hospital products, which is one of the cases you've been referred to. Can I just see, before I ask you to get that up, whether in fact you will benefit significantly? Yeah, no, I won't ask you to go to it. In hospital products, just so that you've got the note, it's page 2616. It cites the passage we just looked at from Jarvis, and the court there says correctly, that Mr. Justice Upjohn observed correctly, in my opinion, that it's not possible to say that one approach is universally to be preferred to the other, for each case depends on its own facts, and the form of inquiry which ought to be directed must vary according to the circumstances. So hospital products is just a more recent...
Mr. Crowe, would it be a legitimate or illegitimate gloss on Lord Upjohn's concept of a general rule that has to be applied anxiously on a careful investigation of particular facts, to say that one may be assisted in seeing whether, or if so, to what extent the rule applies, by keeping firmly in mind the purpose for which the rule is there? Rules of this kind have a habit of becoming sort of placed on mantelpieces in glass cases.
Yes.
Here, it's a rule designed to ensure single-minded loyalty.
Absolutely, and exactly so. We would urge, and in a sense this sort of spills over into the next topic, it's headed deterrence, but actually it's really a sort of salutary rule. It's not so much deterrence, it is encouraging, as my Lords was suggesting an argument, yes, it's encouraging good behaviour. It's by holding a large stick, but yes.
But it does, as Lord Wolfson says, it does apply for people who may accidentally become fiduciaries.
Yes.
That if here the protagonists had contracted as individuals with each other, that nobody would say that they owed each other fiduciary duties, and if their corporate alter egos had contracted with each other, I mean, subject to whether it was a joint venture or a partnership, they wouldn't. As it happened, one of them became the director of the other one's alter ego corporate entity. It might not have been done by that. Does he then suddenly owe these fiduciary duties to that company?
Well, the answer to that question is irrelevant for the purposes of this appeal. And that, in a sense, was the intended thrust of my very opening remarks yesterday afternoon. because this appeal proceeds on the basis that fiduciary duties are owed. We can quite see that there may be arguments on other facts for saying that a fiduciary duty should not be owed. But the whole predicate for this appeal is that fiduciary duties are owed.
Yeah, they were owed because he became a director of the company.
Yeah.
So you're not... It would be a big step in the law to say, well, some directors in certain circumstances don't owe a fiduciary duty to the company.
Exactly.
But we're not being invited to take that step. But even if, as you're right, that the fiduciary duty was owed, is the liability to account affected by the circumstances in which that duty arose, or do those circumstances affect the scope of the duty in a way which then influences whether there should be this liability to account?
Well, there will certainly be situations in which, and I think my Lord Reed's judgment in FHR touches on this, that there are certainly, in a commercial context, one of the questions that will be asked is in relation to what activities is the fiduciary duty owed in the commercial context? Because it may well be that the particular structure of a commercial relationship is such that fiduciary duties are only owed in respect of particular activities. And again, since we mentioned it a moment ago, Warman and Dwyer, I think is an illustration of that, because that was, as far as I think I'm thinking of the right case, it was the case where there was a distributorship agreement between an Australian distributor and a US manufacturer. And the Australian distributor then decided it would be a much better idea to make and distribute the products themselves. And their fiduciary relationship existed in relation to the distributorship agreement, not in relation to the manufacture, the actual production of the assets, because they didn't have any fiduciary relationships in relation to that aspect of the US claimant company's business. So in that sort of fact situation will certainly give rise to questions in the commercial context of in respect of which activities is the fiduciary duty owed. And I can quite see that nuanced answers may be given, depending on facts of other cases, to that question. But as I say, that's not a live issue in this appeal, because this appeal proceeds on the basis that fiduciary duties were owed to the claimant companies in relation to whatever you call it, the business opportunity of bidding for, performing and being paid for the recovery services. So yeah, I'll come back to that. Thank you. Just to finish on the thread, so we looked at Jarvis. I've mentioned hospital products. There's a short passage in CMS Dolphin, just to finish on this thread, about the need, about the desirability of expressing principles at a relatively high level of generality, and the fact that the absence of firm rules or exhaustive definitions is not a matter of criticism, which is how it is presented against you. So CMS Dolphin, another case involving leaving and competing by a director. CMS Dolphin at page 1564. And you'll see Mr. Justice Lawrence Collins at paragraph 97, just over halfway down, page 1564. Under the heading duty to account, in many cases, an account of profits will be a more advantageous remedy than equitable compensation, since the actual profits obtained by the director may be higher than the damages for the loss of opportunities suffered by the company, particularly where, as in IDC and Cooley, the company had little or no prospect of obtaining the benefit of the opportunity. The fiduciary is liable for the whole of the profit. There are no firm rules for determining which is the relevant profit, and he then cites hospital products, which, as I say, in turn cited Jarvis. Whereas here, the business, to use a neutral term, not distinguishing between the individual and the company, is not restricted exclusively to the performance of contracts which are obtained from particular client, the fiduciary should be accountable for the profits properly attributable to the breach of fiduciary duty, taking into account the expenses connected with those profits and a reasonable allowance for overheads, but not necessarily salary, and so on. And then at the end of that page, for example, other contracts might not have been won or profits made on them without, for example, the opportunity or cash flow benefit which flowed from contracts unlawfully obtained. There must, however, be some reasonable connection between the breach of duty and the profits for which the fiduciary is accountable. So that, I just wanted to finish that as the last of our illustrations of cases expressing the relatively open-textured nature of the existing rule without indicating the slightest difficulty in applying it. As I say, this, to be absolutely clear, this whole line of argument on our part is responsive only to the suggestion that the existing test is so unclear that it must be abandoned. We suggest there is no basis for advancing that argument. The test has been expressed in general terms and applied without difficulty. One of my learned friend's observations in opening was to say that this is an area of the law that hasn't been in front of the highest tribunal for some 60 years or so, and therefore it needs to be revisited. It hasn't been in front of the highest tribunal for some 60 years, but that the therefore in that sentence is a non sequitur. It may well be, and this is speculation, that it hasn't troubled the highest court because it is in fact not causing any problems in practice. It has been applied by the courts in this jurisdiction and in many others, but for our purposes in this jurisdiction without any apparent difficulty. Can I just take one liberty, which is that in his work on the principles of equity and trusts, Professor Virgo says that English law requires profits to be disgorged no matter how tenuous the connection may be between the profit and the breach. I won't ask you to go to it, but if you want to see it, it's on page 3664.
360. Mr. Crowe, can I just make this brief observation? When cases are pleaded, I mean, what we're engaged in here is a very sort of high-level discussion as to what the overarching principle is. But when cases are pleaded, I would suggest that in a case such as this, the pleader is unlikely to use the phrase sufficient connection. Judging from my own experience, if I may, they're much more likely to use the formula used by Lord Wright in Regal Hastings, if that's the type of case. In other words, the general principle is applied in individual cases with a degree of particularity by reference to the facts of the case.
Yes.
And I don't think I give much away to say I think I many times pleaded cases of this sort using Lord Wright's formula, and I often saw it.
And again, in a sense, that is, albeit in an anecdotal way, but it is valuable for that as an illustration of the way that the existing test has been operated without the slightest difficulty.
Is it also common for there to be a split trial, for there to be a trial of the question whether there was a breach of duty, and then the claimant has to make their election whether they want an account or equitable compensation, and then the sorting out of how much money is involved?
I can't give you a sort of statistically verifiable answer. I think the only response one can offer is that the question whether there is a split trial will very much depend partly on the size, just the scale of the case, but also on the nature of the what might be the stage 2 trial. I mean, in some cases there may be hotly contested disputes on liability, but a pretty clear answer on quantum. In other cases, it may be the other way around, and there may be very obviously a liability, but there may be fantastically complicated accounting evidence as to the quantum. So I'm not sure I can offer a useful. I haven't myself done enough trials, even on a sort of personal basis, to give an answer. But split trials are common if there's a good enough reason for them, and the good enough reason is normally the scale of the inquiry that would be involved on quantification and the saving that would be made in not having to do that before liability is determined.
I'm afraid with 7 justices putting questions to you, an awful lot of time is taken up with this. We must let you make progress because you're still on page 11 of 50.
Well, this is true.
So we'll see if we can just let you have a clear run through to 1 o'clock.
My Lord, you're extremely kind. I personally find it far easier responding to questions rather than conducting a monologue. If you're disheartened by the fact that I'm only on page 11, the fact is that the way that we are dealing with it now, our case, in fact, in writing is sort of in 2 halves. We sort of put our positive case and then we answer theirs. I'm not going to do that on my feet because in presenting our positive case, I am answering theirs. So in real terms, I only need to get to about page 25. So I'm grateful for your Lordship's concern, but at the moment, I'm not downhearted myself. So just in terms of closing, the final observations about this question of sufficient connection, I just wanted to respond, since it's in the authorities bundle, to Professor Virgo's observations. I say that English law requires profits to be disgorged no matter how tenuous the connection may be between the profit and the breach. In our submission, that is a rhetorical flourish, which is not justified by an application of the test that currently exists. If something only has a tenuous connection, it is liable to have a sufficient connection for the purposes of imposing liability. But that I think, doesn't need to be explored much further. The only other point under this heading is the question, to some extent we've already touched on this, is the question is whether the existing sufficient connection test could properly be described as a form of a causal analysis. To be honest, as I say, we're relatively agnostic on how you view it. Our only purpose in this appeal is to resist its replacement rather than to help you define it or refine it if that is what you consider appropriate. The only point we were going to make on this question as to whether or not the existing sufficient connection is a form of causal analysis. The only point we would make in that regard is this, that, and we can perfectly see there is an argument for saying that it is a form of causal analysis. And indeed, I think, again, just mentioning, Professor Virgo himself says as much in his work on the principles of equity and trusts at page 3663. And I think we detect the same assertion in my learned friend's case at paragraph 34. I don't ask you particularly to go to that, but again, we apprehend the appellants themselves appear to suggest that the case law has treated the sufficient connection test as a form of a causal inquiry. As I say, we're fairly neutral as to whether that's the right analysis. If it's the right analysis, we would simply say that it doesn't assist my learned friend. Indeed, quite the reverse. Because what my learned friend is suggesting is that a coherent structure for the remedy is to have some kind of causal inquiry. He has his own preferred version of that, But his starting point is to say, well, the court ought to be conducting a form of causal inquiry, if in fact that is what it is doing by means of the sufficient connection test. Then the law as it currently stands already performs the function that he would wish it to do, although not going as far as he would wish it to go, which we will get to in a moment. So we have got, indeed, as my Lord Reid points out, on page 11, page 194 of the bundle, and I think in the course of exchanges with the court, we've covered the grounds that's identified in paragraphs 22 and 23, and in 24, I don't think we need to explore that. We've had some detailed exchanges on the extent to which the liability is purely status-based, or whether there is an element of breach that is required. And I was going to move on to page 199. Simply to point out, because as we work our way through the argument, I'm attempting to put in place some markers which we will then collect up later on when making a slightly more general address about the alleged harshness of the existing law. And one of the markers we just put down in paragraph 25 is to say that the application of the sufficient connection test is responsive to the circumstances of each case, really, in a sense, one need to say no more than that. It is a flexible tool, and if it is, as I think my Lord Briggs said in that article that we've already had drawn to our attention, if it is nice for judges but leaves the academics feeling a little short-changed, that should hardly be regarded as a criticism, because it is the judges that have to deal with cases, and they do so by attempting to do so justly. If the academic analysis is not as granular as some might wish, that is not by any means necessarily a bad thing.
I think I had a more lowly motive in mind, which is avoiding being too frequently overturned by the Court of Appeal.
Well, I would think it's a badge of honour for a trial judge to be overturned by the Court of Appeal, in the sense that it probably indicates that the trial judge is only being entrusted with the difficult cases on which different views can subsequently be taken. Paragraph 26 of our case, we simply mention the point that if I can try and capture it in a sense with a soundbite, and we've probably touched on this already. The reason we have, as I say, balked slightly at the use of this expression causal connection is because of the risk of getting one's mindset into the world of tortious contractual damages causation, and that is an entirely different line of thought and line of authority, and so we just wanted to sort of make clear that if you are attracted by the idea of describing the sufficient connection test as a form of causal inquiry, then it certainly would, I think, help in terms of clarifying the law for mere practitioners to make clear that causation is not what the court is talking about. So we move on to deterrence, which is a sort of a label we use with a certain amount of diffidence, because as I suggest, the rule is not, the existing state of the law is not the product of some antiquated and censorious approach, harking back to the 18th and 19th centuries. The principle upon which the liability to account is based is the principle of undivided loyalty. Deterrence, if one can use it because it's the word that has been used, we would prefer to keep in mind, as I said a moment ago, the idea that the rule has a salutary effect. Now, with respect, my learned friend advanced his argument on deterrence in a way that not only would we disagree with, but with the greatest respect, we suggest that his entire argument was back to front. his argument was that we have not made a sufficiently good case for the deterrent effect of the rule in its current form. We, this side of the court, are not addressing the Law Reform Commission with a blank sheet of paper seeking to devise a cause of action from scratch. The fact is that we are hearing an appeal from the appellants who are asking you to change the law, which has been analysed and upheld literally for centuries on the basis that the existing rule is salutary because of its deterrent effect. It's not for me to say that Lord Eldon was right, because it's for my learned friend to persuade you that the previous case law is so wrong, demonstrably so wrong, that it should be changed. And he does so as a lawyer's submission with no empirical evidence as to the absence of the deterrent effect. That being the framework for this debate, in our submission there is, with the greatest respect, literally nothing in my learned friend's argument which should lead you to the conclusion that the but-for test should be introduced, because it won't make the slightest difference to the deterrent principle. In our submission, the starting point is that this is how the law has been articulated and justified for centuries. Taking interventions from the bench, from right to left, my Lord Richards yesterday suggested that the existence of the rule encourages good behaviour by encouraging fiduciaries to seek authorisation in cases where authorisation is an appropriate and available solution to what would otherwise be a problem. My Lord Briggs suggested that the existing rule encourages or upholds or vindicates the principle of single-minded loyalty. My Lord Hodge made an observation regarding the existence of, so to speak, unprosecuted crimes on the statute book. Their value is not in how often they are prosecuted, but the effect that they have by being there. And although my Lord Leggett suggested it may be dangerous for mere lawyers to make submissions by reference to what is likely to happen in the commercial world as to the likely effect, that is, with the greatest respect, a point against my learned friend, because it is his case as to the likely absence of any erosion of the deterrent effect that he is seeking to use as a support for his line of argument. So our starting point on deterrence is essentially very straightforward. This is what the courts have been saying for a very long time. It is inherently, internally, fully coherent as a proposition. Nothing my learned friend has said should lead you to the view that adopting his approach would do anything other than act as a positive incentive to venal fiduciaries to try their luck. Because the worst that could happen, if my learned friend is right, the worst that could happen is that they don't make the unauthorised gain that they might otherwise have done. And with respect, the answers he gave as to why his solution would not have a corrosive effect on the deterrent principle are it is not unkind to say so, naive. The suggestion that somebody would be discouraged by the embarrassment of the risk of being sued publicly, rather than applying their mind to the brutal reality of whether they're going to make money out of it, is just not realistic. And in any event, it entirely ignores the possibility that the rapacious, dishonest fiduciary, and cases absolutely happen like this, so deprive the beneficiary of assets that they never get sued because the beneficiary hasn't got the wherewithal to chase them down. There are cases where agreements have been made which are covered by arbitration, in which case the defaulting fiduciary will never have the dirty laundry washed in public because it will be being done behind closed doors. The idea that a risk of litigation is a sufficient deterrent in our submission or for that matter, this idea that somehow flipping the burden of proof in relation to dishonest fiduciaries is a sufficient deterrent, is simply written water. There is nothing to support any of that. And the other point we just wanted to emphasise, there was one point my learned friend made on his feet which wasn't made in his case, but it was, I think, backed off Professor Jones' comments about Baldwin and Fitz when it first came out, saying he was worried this was going to discourage private enterprise. With respect, we find that a baffling proposition because the liability of a fiduciary to account for unauthorised profits is not a discouragement to private enterprise, to money-making activities. It's a discouragement to unauthorised money-making activities where authority should be obtained.
Well, what I understood Professor Jones's argument to be was that in the case of Baldwin and Fitz, it was taking it too far because there what had happened was that a benefit had positively been conferred on the trust, which they never could otherwise have acquired. Yeah. And that to discourage that sort of activity was taking it too far. Yeah. Now, one can have different views about that, but it seems to me that that doesn't arise in this case. There's no question of any benefit having been conferred on the claimants.
And without anticipating too much, one of the other sort of markers that will be picked up in relation to the overall question about whether the existing regime is unduly harsh is that both the Trustee Act and the Companies Act include express provisions allowing relief in relation to trustees or directors who've acted honestly and reasonably. So there are any number of, in a sense, if you call them mitigating possibilities out there. The other point we just wanted to pick up in paragraph 28 of our case, and again, I've sort of slightly touched on this already, but we do urge on you that the concept of deterrence, and indeed the whole structure of the rule, is not based on some sort of antiquated, outdated concepts of propriety. It is based on what we submit is a realistic acceptance by equity of, in the words of Bray and Ford, human nature being what it is. Equity knows perfectly well that people give in to temptation and are also perfectly capable of deceiving themselves that they aren't giving in to temptation. Self-deception is, as well as naked dishonesty, is an active part of the human psyche. And it's one of the reasons when we get on to the question of the apparent evidential difficulties in sorting out liability if a different test was applied. Self-deception is one of the other difficulties that the court will encounter, and it's, in our submission, unduly mechanistic, formulaic, for my learned friend to sort of divide fiduciaries between honest ones and dishonest ones. I don't know about your ladyship and your lordships, but my experience has generally been in practice that very few clients set out avowedly being dishonest in a way that they recognise as dishonest. They find themselves doing things which suit their purposes, and they persuade themselves that they're doing it with the best possible motives. So to treat the honest and dishonest people as sort of two hermetically sealed different categories is, in our submission, unduly, as I say, formulaic. So we've mentioned in the footnote 83 the Bray and Ford reference to equity's realistic acceptance of human nature being what it is. Could I just add one other reference, which may just be useful to look at very briefly, in one of the academic commentaries, which just happens to quote another case, which isn't in the bundle. The case isn't in the bundle, the academic commentary is, but it just provides another hook in the case law in relation to this same thread. And it's in one of Matthew Connellan's articles. The article itself starts at page 3108. The extent of fiduciary accounting, and the importance of authorisation mechanisms. The passage I just wanted to draw to your attention is at page 3116. And under the heading Positive Justification, the second paragraph says this: the view that fiduciary doctrine provides a subsidiary and prophylactic form of protection for non-fiduciary duties cannot be defended in full within the confines of an article such as this, but a skeleton of the argument can be presented. Fiduciary doctrine is based on a fundamentally cynical view of human nature. Taking mankind at large, it is not very safe to allow a man to put his private interest in conflict with the duty which he owes to another. And the footnote for that's a case called Re Blois Trusts, which isn't in the bundle, and he then goes on to quote Bray and Ford as well, which is, I just wanted to draw that to your attention simply as an illustration, in fact, just in case you were left with any lurking feeling.
What does he mean by non-fiduciary duties being breached? I don't understand that.
One of Professor Connellan's analyses, and I think this is shared with Professor Lionel Smith, is that the fiduciary responsibility, well, put it this way around, that the primary duties of a fiduciary are non-fiduciary. It's to do a good job, good, sufficient due care and attention, and that the fiduciary duties are owed, in a sense, as a fortification, as a guarantee of the performance of the non-fiduciary responsibilities. It's not as a line of analysis that we need to urge on you, but I think that's the context in which
all right, thank you.
It comes up. So, as I say, all we wanted to get across, going back to our paragraph 28, is that the basis upon which the existing law has been founded is the points of principle that we've already examined. First of all, which is the duty of undivided loyalty and the obligation to account for unauthorised profits that flows from that. And secondly, it is based, as we say, on an entirely clear-sighted attitude to human nature, rather than on any outdated principles of morality. We have, and I probably, having said what I've said orally, I don't need to go back over it. If you just flick forward, having said that we're just trying to capture everything in one run-through rather than revisiting points, if you just flick forward in our case to page 213, you will see at paragraphs 60 and 61 our detailed written response, and I don't think there's any particular benefit in going over that orally. That's where you'll find our detailed written response to the suggestion that the solution for which Malone and friends are arguing would not undermine the existing deterrent effect of the rule. Lord, I'm conscious of the time. I'm also, if it's of any reassurance, comfortable with the progress. So if that's a convenient moment to the court.
Yes, certainly. We'll adjourn now and resume at 2 o'clock.